Hello, everybody, and welcome to the State of Estates podcast. I'm your host, Griffin Bridgers, and for this first episode of our podcast, we're going to be interviewing Ethan Rector. I used to work with Ethan at a previous firm, and Ethan is now a founding partner at Cook Rector Law, where he specializes in estate planning for families and business owners. Welcome, Ethan.
Thank you, Griffin. Pleasure to be here.
Yeah, absolutely. Thanks for joining us today. And we'll get into your background in a minute, but I wanted to mention that in the midst of all the COVID madness right now and everything like that, you've recently made the transition in founding Cook Rector Law. And can you tell me a bit about that and what it's been like kind of going out on your own and making that transition, especially during this current time?
Well, it's been a smooth transition, smoother than I initially would have thought. If you had asked me, I'm going to be leaving the old law firm I was at a year ago, there's always a concern about how things are going to go from a business perspective, from a client service perspective. But it's been a smooth transition. The transition, I guess, was a long time coming. I'll talk to you a little bit more in a little bit about where I started as an attorney and where I've been, but I began the discussion with my partner, Mike Cook, and we founded Cook Rector Law together about potentially joining him and forming a partnership in the middle of last year. It's always tough to find the right time to pull the trigger when you're jumping from a larger law firm to forming your own. It's worked out pretty well. I made the jump at the end of January. Business has been great since then.
Excellent. Well, that's great to hear. So as a segue, you alluded to this going back to starting point in the practice of law, but I guess let's hear a little bit more about Ethan. When did you first decide to become a lawyer, and what led you to this career field?
Well, my first exposure to any sort of legal education was actually back when I was an undergrad at the University of Southern California in Los Angeles. Fight on, by the way, on that. I was studying broadcast journalism. I actually dreamed growing up of being a sports broadcaster. And I studied sports journalism at USC and actually had the opportunity to work after I got out of USC in television news for a few years doing sports anchoring and sports reporting, and I loved that job. But at USC, as part of that training to become a broadcast journalist, I had to take a communications law class because that's very important, as any reporter can tell you, any journalist can tell you in how you do your job. And I loved the class. I was absolutely hooked on the topic, and I kind of decided at that point that if I ever wanted to get out of the news business and find another career, I was going to look at becoming a lawyer because I loved it. I was completely intrigued by the subject and how everything works. And after spending a few years working in the journalism field, I decided that I didn't want that to be my long-term career. Loved the job, hated the lifestyle, I guess you could say. And so that's what prompted me to go off to law school at that point in time. And here we are. I guess this is started law school in 2007, so 13 years later.
Wow. Okay. And then in terms of where you're at now, you're obviously in estate planning and you've made that jump from broadcast journalism. So in the field of law itself, when did you get interested in estate planning and how did you really get involved in this particular area of law?
Well, actually, the truth is I fell into it. I didn't take a trust and estates course in law school until my third year. After I took my first trust and estates course, I realized this is an area of law I really liked. Unfortunately, I didn't have any more years of law school to take any other kind of supplementary classes to enhance my legal education in that area. And when I came out of law school, I came out right in the midst of the recession in 2010, where there weren't a lot of legal jobs out there. And with my unusual career path, I had a prior career. When I got out, I was married with 2 kids already. I didn't have maybe some of the opportunities that some of my classmates who were single and younger had to really go out and spend all their time, volunteering or working as a clerk in a larger law firm to get that experience. So for me, it was just take the first job opportunity that I can get and then see where it leads me. And my wife and I knew we wanted to move to Colorado, and through a colleague of mine or a classmate of mine at Marquette University Law School, I had the opportunity to come out here to Colorado and work for a a woman who was a solo practitioner in estate planning and was looking to bring me on kind of as her successor. Now, that didn't end up working out overall, but she had just did estate planning, and that's kind of where I fell into it, and it fit me naturally as I started doing the work based upon my past experience.
Yeah. And then what's your career trajectory been like from there? Obviously you've stayed in the field of estate planning largely since then, but how have you've seen that play out from being a newbie lawyer out of Marquette, just moving to Colorado, to now being out on your own, being, a partner in a firm founded with Mike Cook, and, kind of making that leap?
I spent 4 years working for that solo practitioner before I realized that we had some differences in how things were going to play out moving forward. And actually, in my last year working for her, I met Mike Cook. He was working for another law firm up in Denver-based law firm that had just opened up a satellite office in Colorado Springs. This was back at the end of 2014. And we got to talking, and he liked the idea of bringing me into this firm. And I pulled the trigger at the end of 2014 and joined this firm, which then was subsequently merged into a larger regional law firm, as you know. You were part of that merger with me back at the end of 2016. But even after leaving the solo practitioner firm back in 2014, I always kind of knew that I would be falling back into a small firm environment again. I think that fits the practice of estate planning better than working at large law firms. Now, there's very successful estate planning attorneys who work at very large law firms. But the majority of estate planning attorneys that I know and that are very successful actually work, for the most part, for themselves or in a smaller boutique type firm, kind of like your firm. And so I kind of knew I'd be falling back into that, and maybe even running my own firm. That was always a goal of mine. And when Mike Cook left that larger regional law firm in 2019, we'd always discussed the possibility of potentially partnering in the future, and he kept the door open, and we kept the lines of communication open, and finally pulled the trigger at the beginning of this year.
That's awesome. Okay. Well, that being said, we've looked at you. Now we'll kind of shift to who your ideal client is. Who do you like to work with, and who really ignites your fire in terms of getting up in the morning and going and serving their needs?
Well, to be honest with you, I'm not sure if I have one. It's certainly not about the money. A lot of people say, the higher net worth client, the more opportunity there is for complex planning, which is always fun. And obviously, the more needs there are, the more money you're going to make in the process. And we're business people. We realize that. But, what I found is if I'm dealing with a widow, in her 80s and 90s, and all she's got is a house and maybe $100,000 in assets, well, that means as much to her, and the planning process means as much to her as the clients I represent, who have assets in the eight figures, we're worth tens of millions of dollars. Again, the high net worth clients may be more fun to tackle, but my ideal client, the best clients, are the ones who really come in, sit down in your office, and open up, right? They share their life story. They talk about what money means to them, because you can often get into the mindset that this is just about your assets. Who's going to get this, and who's going to get this, and who's going to get this, and we don't really talk about values, passing down values. But when I get clients who come into the office, who open up, share their life story, talk about what money means to them, what they've gone through in their life, what I can often help them do is craft a plan that is going to reflect their needs, what they need, but also it's going to reflect their values, their humanity, and get their loved ones to try to consider living the life that the client has lived, that hard-working life, that life that's charitable in nature in many situations, and being a productive member of society rather than just your cookie cutter, I'm going to leave things down to the kids and that's that. Those are my ideal clients. And actually really helped me, Griffin, my journalism practice. That's actually helped me from a communication standpoint. And that's really what I really like about having that background is it's given me the training to understand that you have to ask questions. And when I sit down with clients and I'm able to ask questions, I'm able to get more out of them and really help them draft that plan that meets their values, not just their needs.
Okay. Yeah, just a quick aside, were you more in print media or actual broadcast journalism?
Yeah, I was a broadcast journalist. So yeah, I was
Okay.
a television anchor and reporter. So I had to keep in mind the visual and the written word when I was putting together stories.
So technically, you and I should be swapping positions right now. Don't judge me too harshly on my podcast interview abilities. But no, that's a great point you made, and I feel like a lot of attorneys often look at, okay, I provide a service, and how does that service meet a client's needs? But you really kind of hit on a great point of what do not only the services you provide, but the relationship you have and your unique skills actually mean to the client, and how do they feel when they leave your office? And I feel like that's something that is often glossed over when you're stuck in the minutia and technical details of estate planning itself.
Certainly. Yeah, and it means a lot to me too. With my background, I'm married with 4 kids, and I have a daughter with special needs, and so when I'm working with families like that who have to do planning for loved ones, for putting together mechanisms in place to care for those loved ones for the rest of their life, that's really my passion in that area.
Great. No, that's awesome. Yeah, and I think we've really gotten a sense of who you are and what you like and what drives you. So from there, I think we're ready to talk our craft and get into the details of our topical discussion for the day. So for today, we're going to focus on estate planning for the ownership of interests in business entities. So, it's often the case for our audience out there that, you might be dealing with your own ownership in a business that you have, that you founded, much like Ethan has done with Mike Cook, or situation where maybe you've inherited an interest or bought into an interest in a business over time. And when it comes to planning your estate and how that business interest is going to factor into the flow of assets and the valuation and everything that goes on in wrapping up your final affairs, what Ethan has brought to my attention is the fact that oftentimes there's a lot of hidden issues and pitfalls that are overlooked and not necessarily addressed in full. So today we're going to really kind of get into the weeds on how titling of business interests, whether it be in an individual's name or a revocable trust or subject to things like buy-sell agreements, could, if done incorrectly, delay the transition of a business at a time where it really needs a seamless transition after an owner's death or a key person's death. And we'll also, from there, look at how estate planners, as you're dealing with them, or if you are one, how you can leverage various non-probate transfers potentially as a solution to this potential delay. Before we get into it, Ethan, you'll probably appreciate this if you've seen the movie Tommy Boy. I often teach business succession, and I like to cite the movie Tommy Boy as the ultimate primer on what not to do when it comes to business succession planning. So if anybody wants to go watch that, if you haven't seen it, I'd encourage you to do so. But let's jump right into our material for the day. So I guess, Ethan, starting out, what are some of the general issues you see with business interests and estates that estate planners and wealth planners often overlook?
Well, I think the first big one kind of relates back to what we were talking about as far as my ideal client goes, and that's the fact that there are estate planners out there that don't consider the life's work that a lot of clients put into their business. It's not just another asset. It reflects values. And a lot of clients want to see that business continue on, whether it's in their hands or whether it's in a family member's hands or in the hands of a trusted employee that they had through the years, or even a third party who will be a caretaker of that business into the future. So you can't just look at it, business interest is just something that's there to be passed on. It's part of a business, and that business represents a life's work and reflects the values of the person who runs it. And I think that needs to be considered in the planning process, and estate planners need to consider that when they're doing planning. The second big point I wanted to make is estate planners, the issues that they often face is, or that they often overlook, is that they ignore how a business can be destroyed if there is no plan on how to administer it, especially if no one has the authority to act on its behalf after disability or after the owner is disabled and after death, obviously. There has to be a plan for somebody who can step in and has the legal authority to tackle those things. Third point, and I've got a few more here, they overlook, I think, how a business agreement can restrict the transfer of business interests. And it can even lead to situations where an owner who has passed away isn't even able to realize anything close to the true value of the business, right? So depending on how the agreement is put in place, you can have a situation where an owner thinks that his or her business is going to be worth $500,000, and it ends up being truly worth half of that. So, and that's because there wasn't the right planning done. So you can't just attach a value to it. There's so many different factors that go into how a business is valued, and it can change quite significantly after death as well. Yeah, the fourth thing is, frankly, just a lot of estate planners aren't familiar with the tools that we actually have at our disposal to tackle virtually every situation that could apply to the interest in a business upon an owner's death. There are estate planners out there who refuse to, embrace the need to be corporate attorneys as well, or at least recognize the need to have one involved in the planning process. And this is something I realized very early in my legal career. When I was working for that solo practitioner way back from 2011 to 2014, I was doing just estate planning and wasn't really doing a lot on the business end. And what I found is I had, as my clientele continued to grow, is that, you end up with dozens and dozens of clients who have business interests, and you realize you need to cater to their business needs in connection with their estate planning needs. So you need to be very familiar with that area of law, or at least have a good relationship with another attorney who's familiar with that area of law, and you can partner together to meet the needs of the clients in both of those ways.
Absolutely. That's a great point.
Yeah. And then the final, I guess you can call them, there's two other points I wanted to make. They can relate and they can not relate. But first of all, if you have a taxable estate issue and your business is the majority of the value of your estate, a lack of liquidity can destroy the business. And this happens. You have to have other assets in the estate that are available to handle any potential estate tax issues, or else you could be in a situation where the business has to be sold off, because businesses tend to be very illiquid. There's not a lot you can usually bleed out of them. They need their capital in order to run the business, and having to bleed it dry in order to pay taxes can often destroy the business. So that needs to be kept in mind when you look at somebody's estate and you realize that the business is a big part of that. If it's a taxable estate situation, and right now we don't have a lot of those, just where the current exemptions are at over $11.5 million per person, but we never know what that's going to look like in the future, and that needs to be considered. And then the type of business also matters. So especially if you have a franchise, planning needs to take into account the franchise rules, the franchise agreements, because you can do all the planning that you want, but if you don't take into account the fact that business can only be owned by a certain person, can only be transferred in a specific way, then all your planning gets thrown out the window. So those are the 5 or 6 points that really, I think, or the 5 or 6 issues, I think, dealing with business interests in the states that planners can often overlook and that they need to take better account of.
No, that's a great summary and rundown. A lot of things I hadn't thought of either. One thing you alluded to, in terms of the toolbox for attorneys is, as estate planners dealing in this area, it's important to kind of put on, the corporate attorney hat and know some of the issues that can come up in that area of law. So you'd alluded to tools that are often overlooked by estate planners. What are some of those tools that you have seen or that are kind of top of mind for you?
Well, when dealing with business interests, I think at least for the simple planning on where the interests go at death, I think that we need to look at our non-probate transfer tools as a way to get the business down to the next generation or to whomever it's being left to, as opposed to allowing the business interest to flow through the probate estate. As you know, Griffin, probate in Colorado is not as difficult as it is in other states. And I think that avoiding it is often oversold as a major issue for clients. But when it comes to businesses, you can't afford any delay in having somebody who has the ability to manage that business after the owners die. And so using those non-probate transfer tools as a way to immediately vest somebody with the ownership or with the right to make decisions with regard to that business is very important. And so, one of those things is obviously the use of trusts. If you can use a revocable trust as your main tool, your will substitute for transferring the ownership of your business interests, your successor trustee can immediately take control of that business, appoint the right people to manage that business after your death, and keep things running, keep the employees paid, keep the money coming in, make sure that those important decisions are being made, and then, implement any buyouts that occur after that point in time. If family isn't going to continue running it, at least allow the business to be sold seamlessly to the employee or to the third party who's going to purchase it and run it into the future. So I think trusts are the best tool. Obviously, your business has to have value as a going concern, really, to make that an option. But I think that's certainly something that if you're a business owner, you should look at a trust as opposed to just doing will planning as the way of passing your interests on. And then the second thing is the use of beneficiary designations on business interests. Not a lot of estate planners realize you can even do that. You can put a beneficiary on a life insurance policy or a retirement account, on a bank account, on a brokerage account. And here in Colorado, as in I think the majority of states now, you can even put a beneficiary on a piece of real estate through the use of a beneficiary deed. But a lot of people don't realize, a lot of estate planners don't realize, is that you can simply register the business interest in beneficiary form using a Colorado statute. Uniform Transfer on Death Securities Act, I think it's been adopted in many different states, but we have adopted it here in Colorado. It's under the revised statute, section 15.15.301, and it basically sets forth that you can register your interests in beneficiary form, and it's just as simple as drawing up the corporate documentation to reflect that the ownership of the interest is in beneficiary form. You name the beneficiary of the interest, and then at your death, it automatically passes to that beneficiary. It's not subject to probate, and then whoever that beneficiary is, if it's the child who's going to continue to run the business, if it's another friend or another individual that you've reached an agreement on to leave the business to, they can immediately take it over and continue to run it.
Oh, that's great. You mentioned registering a security and how that can be kind of the tool you use to gain the advantage of that beneficiary designation, and you mentioned the corporate documents. How do you go about, engaging in that process of actually registering the security and creating the beneficiary designation that's attached to it?
Well, it's as simply as having a corporate resolution in place in which the company approves the registration of securities in beneficiary form. So the company always does have to approve that. And then once that happens, having just basically a written request from the shareholder, having the shareholder provide a written request or member provide a written request to register the interest in beneficiary form, and then a follow-up letter from the company back to the shareholder or member basically acknowledging that the interest has been registered in beneficiary form. If it's a certificated interest, you should note that on the certificate, either have a new certificate issued or have some sort of designation on the back noting that it's owned in beneficiary form and who that beneficiary is. But it's truly as simple as that. The fact is, though, is when I do planning for business owners, you can do that, but it's often best when you're setting up the business to take that into account, and I often do it in the actual shareholders, partnership, or operating agreement. We just note in the back of it that the interest, the membership interest, the partnership interest is owned in beneficiary form, and here's who the beneficiary is. And then at death, the shares or interest will automatically pass to the beneficiary.
Great. And if I'm not mistaken, you know the Act a little bit more than I do, but in terms of the Uniform Transfers on Death Act, I know a lot of times there's a lot of hand-wringing over how do you wordsmith a beneficiary designation, but am I correctly recalling that there's some provisions in there that actually set out some express language that you can use to comply with that?
You're certainly correct on that. They actually have examples. on
Yeah.
how to do it. And
It's rare.
and the attorneys that do take advantage of this pretty much steal those examples and just use that as the way that they go ahead and register it. It's just it's as simple as just putting a name, TOD, and then another name, and then that second name is the person who's the beneficiary and who's going to receive it. Now, I typically note in there when I'm doing it that it's registered in beneficiary form under the Act. I reference the Act because you never want somebody to question, and I use, for example, a bank, a financial institution. You have a business that has a bank account at a bank, and you're going in as the successor owner of the business, the sole owner of the shares or interests after the owner has passed away, and you're saying, I have the authority to get in there. You want to be able to give that financial institution as much information as possible where they don't question whether what you're doing is legal or not, because a lot of them aren't familiar with the concept of putting business interests in beneficiary form. So having that, not only having the right language, but providing a little extra detail that it is registered in beneficiary form pursuant to a Colorado law, at least then their legal department will know where to look and then, rubber stamp the ability of the beneficiary to get into the bank account, to have the authority to use the funds in there to continue to operate the business.
Okay. That's great. Yeah, I learned something today, even on the TOD Act. Even though I reviewed it, getting ready for today's talk. But I guess now that we've kind of looked at that high level piece, maybe we can dive into the details of how there's different business ownership situations where you can utilize this type of tool. And as we're going through that, I also bring up the fact that, especially between spouses, you have other ways to avoid probate through ownership, like in joint tenancy, or if you have a state that allows it, tenancy by the entirety. There's lots of ways to have transfer by operation of law upon death. So maybe, what do the solutions, trust or joint tenancy or TOD, look like as we look at married co-owners as opposed to maybe intra-family ownership or maybe even down the pike, non-related ownership between employees who kind of become a long-term family, with the owner, but aren't necessarily related by blood at the time of an owner's death?
Sure. Well, for co-owners of a business who happen to be married, you can just register each of the interests of husband and wife in beneficiary form, and then at death, the surviving spouse will own the entire business. You mentioned the fact that, you can actually, in the Uniform Transfer on Death Securities Act mentions this, is you can register interest in joint tenancy in a business. But the problem with doing that is that you then only have one owner of the business. And while that sounds like a great thing, you don't have to worry about the potential transfer issues upon death. You're not getting the best asset protection when it comes to the business. Having actual multiple owners filing that partnership tax return every year, if you're a partnership, or an S-corp return showing that there are two shareholders, that's going to provide better liability protection, specifically inside liability protection, than having a single owner company. If the business is being sued, obviously if the business is being run the correct way, you'll be able to keep that corporate veil in place and keep your personal interest protected for any business liability. But if any of the owners of the business become personally liable on another matter, especially in a joint tenancy situation, if one of the joint owners becomes liable, well, then the entire interest in the business becomes subject potentially to being taken by a creditor in a lawsuit. Whereas if you have just one of the spouses liable and the appropriate type of agreement in place between the members or shareholders of the company, what we can do is often ensure that the second owner continues to be able to control and run the business, and all that creditor is able to come after is any profits that are distributed out related to the interest of the shareholder or member who was sued. So it provides a lot better protection to have two owners rather than to have just the one owner and have the joint tenancy ownership in the shares. I do want to bring up one thing here, and I see this quite often, is you have to be careful if you are a situation where you've got a husband and wife who run the business and they decide that they're going to change the ownership of the business into the name of a joint trust. You have to be very careful with the terms of the joint trust to make sure that the interest will still be considered owned by two different parties rather than just one party, the trust itself. So you have to be very careful, and that's really where planning for business interests and estate planning, that's one of those issues where you have to make sure that things meld together very well.
That's true. Yeah, I think a lot of practitioners don't think about that, is that if you have to have two partners of a partnership and you put those interests into a joint trust, then technically you don't have two owners on paper anymore. So
yeah, and that can be changed with the terms of the trust agreement, but you have to be very careful in how you're drafting it. So yeah, those are things that need to be considered all the time when we're talking about married co-owners or married couples co-owning an LLC or a partnership or a corporation. They don't need a complex shareholders agreement or operating agreement if they're an LLC, but they should still have those provisions in there that ensure that a spouse who isn't subject to a judgment creditor can continue to run the business without worrying about any sort of interference from the creditor trying to collect against the spouse who was sued. So that's one of the things that, when we talk about married couples, the things that we need to think about. But when you start dealing with unmarried couples, it becomes a different story. And there's different ways to look at that. You can look at it from a situation where you've got multiple family members who own a company, but they're not married. And the considerations that you have to make on that end. If there are multiple generations, there's things that you need to consider as well. A lot of times if you've got a parent and a child going into a business, for example, well, a lot of times the parent has no problems leaving that interest in that business down to the child, but the child may not feel the same way if the child dies first about leaving his or her entire interest in the business to the parent. They might want their spouse or their own children to realize the equity in that business. And that needs to be planned for typically through the shareholders agreement or the operating or partnership agreement, depending on, obviously, on the type of entity that has been set up. Those things need to be kept in mind in dealing with families all co-owning a business together. If it's unrelated, where they're not even family members who are owning the business, then that's where you're going to spend a lot of time negotiating an agreement between the partners of the company in what happens upon the event of death. But you can still use those tools we talked about, Griffin. So you can still have partners own interests in trust, or partners own their interest in trust, or even in beneficiary form, as long as you have the right, you include the ability for the surviving partner to be able to have the option at a minimum or even a mandatory buyout of the deceased partner, because you want to make sure that the surviving partner isn't stuck doing business with somebody that they don't know or don't even like in some cases. That's a big issue that you always have to consider. But you also want to make sure that the deceased partner is able to realize the equity in their business to the extent possible, and putting it in an agreement is always the better way to go, because if you don't have the agreement in place, a lot of times appraisals can end up determining what that buyout price is going to be, where if you end up setting it ahead of time and having it binding via an agreement, you put the surviving partner in a position where they know exactly what they're going to have to do and able to buy out the deceased partner's interest in the company. And then the deceased partner's family has more certainty in knowing what they're going to get. So that's why it's very important to plan that out.
Absolutely. And then I like that you brought up creditors and liability, mainly because a lot of times people create business entities with the hope of shielding their own personal assets from debts and liabilities of the business, but very few people ever look the other way. Can their interest in the business or the business assets themselves be subject to claims of creditors of an individual owner? And that's one of those where those liabilities can oftentimes accrue during your life, but actually follow you after death. So I guess one big question on all of these is would there be any pitfalls or issues you see dealing with estate creditors upon the death of an owner to be aware of, especially in a situation where maybe a business interest is not subject to probate or is transferred through a non-probate transfer?
Oh, certainly. There's no exceptions in Colorado law that would carve out a business interest from a creditor of an estate if there are not enough assets in the probate estate to be able to satisfy the creditor claims. So the business could always be brought back into the estate, if you will, or the interest in the business in order to satisfy those creditor claims. So that is a consideration that has to be taken into account of, and even running the business moving forward. So it's very important for the executor of an individual's estate or a deceased owner's estate and whoever ends up being the owner of the interest that the deceased owner had in the business to be able to communicate with each other, because if they don't, there could be that surprise. But it is something to keep account of, and that's why it's very important when your business owners are planning, if they are going to have liabilities there, they should plan to have the liquidity in their estate to be able to satisfy them.
Absolutely. And for everybody listening, I want to remind you that we're kind of focusing on Colorado law today, but there is some universal features of what we've discussed that apply in all states, and there's also some nuances that apply in other states that we haven't discussed today either. So it may be the case that your state hasn't adopted the Uniform TOD Act, or that your state treats probate differently, as Ethan looked at earlier and mentioned, or even that business interests might be treated a little bit different under state law in terms of who owns it and what's the domicile of those assets or that business interest upon your death. So, those are things to keep in mind that are beyond the scope of our ability to cover in the short amount of time we have here. But before we wrap up, Ethan, did you have anything else to add in terms of what we've discussed today, or any other issues that you want to bring top of mind to close out with in terms of key takeaways?
As far as closing out, I would say that there's never, especially for business owners, there's never a wrong time to start planning. Okay? The biggest problems that businesses face is when a business owner waits too long to actually start the planning process, and they lose some of the options that would be available to them, those good fits that would allow them to pass along their business interests in the way that they want, reflecting the values that they want, the values that they have. And that's because they wait too long. There should be a plan for a business no later, I would say, than, a comprehensive plan, I would say, no later than 10 years before an individual would like to retire. So, if you're a business owner and you're planning on retiring sometime in your mid-60s and stepping away from the business, you should have a plan in place if something happens to you in the interim, no later than your early 50s. Now, you should always have a plan in place as soon as you start the business, but if you've been waiting on it and you're getting into your mid to late 50s, you're potentially running out of time to put some of the mechanisms in place that will allow you to step away from the business when you want to, but to do so on the terms that you want. And that's because there's things out there that a lot of times we use when we're talking about passing businesses down, such as the ability to get life insurance. Mm-hmm. And when you start getting into your 60s, it starts getting prohibitively expensive to get those life insurance policies, where if you can lock those things in earlier by putting a plan in place, that's something that you want to look at. And then there's things like, finding the right employee, if you will, if it's not going to be a family member taking over the business, potentially finding the right employee that you can train, that you can put in a position to be able to take over the business and put the right type of tools in place, or the right type of, I guess you can call them handcuffs in place to keep that employee at the business. There's the whole concept of the golden handcuffs, which you put around an employee or a key officer in a business that will keep them with the business to allow you to hand it off to them at a later point in time. But if you wait too long to plan, a lot of times they're not going to be in a position where they can afford to buy out your business. And so that's where if you're waiting too long, you can end up hurting yourself. So, we can talk about planning for death and the easiest way to register your interest in your business, or the way that you own the interest in the business to make things easy then. But you don't want to just plan for that. You want to plan for getting out from under your business. And that means starting to tackle the retirement at an early enough age. Absolutely. And I'd say, too, once you have a plan, make sure you keep it updated. I think you and I have both seen the cases of the buy-sell agreement done 25 years ago on yellowed paper that comes into our office, and the valuation is written in and not set by appraisal, and then is maybe one
1/100th of what the business is worth now. And it's one of those where a lot of people want the set it and forget it type of solution, and I don't think anything in estate planning lends itself to set it and forget it, and that's doubly, if not more, true when it comes to business succession planning.
Yeah, certainly, and I like that term. I use that term. It's business succession planning is part of estate planning, and it involves having that business attorney, that corporate attorney, who can work with the estate planner or the estate planner who's got that knowledge, be able to keep all of those things in mind and be able to create a plan that takes into account all of the assets in making the plan.
Absolutely. Well, Ethan, this has been a great discussion, and for everybody out there listening to us, how can our listeners find you?
Well, you can find me on the web. My law firm's website is www.cookrector.com. I am also on LinkedIn, so if you just search up there for Ethan Rector at Cook Rector Law, I'll pop up there, and you can reach out to me in that manner. I also have a Facebook page as well. If you go to facebook.com/Colorado Estate Planning, you can find me there as well. And then, of course, you're going to go ahead and share, Griffin, my email and my phone number.
Absolutely. Well, Ethan, thanks for joining us today and for the great discussion on business succession and the transition of business interests upon the death of an owner. Thank you, audience, for joining in. And as always, if you have any questions, a follow-up to the show, I'd encourage you to reach out to Ethan. So as Ethan mentioned, I'll link his contact information in the program notes accompanying this episode. And then finally, thank you for listening in. State of Estates is dedicated to giving a voice to the next generation of estate planners while capturing the wisdom of current generations of estate planners. We're always happy to host topical discussions of your choosing. So if you're interested in being a guest on the State of Estates podcast, or if you'd like to recommend a guest or even a topic, please feel free to email me at griffin.bridgers@gmail.com. And on behalf of Ethan Rector and myself, thanks again for listening and supporting the podcast.